Welcome to Black Letter Money. Today we'll be discussing what happens to your debt when you die. Most people assume their family will inherit their debt when they die. They spend years worrying about it, avoiding loans, paying things off early, feeling guilty about the balances they carry, and almost everything they believe about it is wrong. Here's what the law actually says about what happens to your debt when you die, and once you understand it, it will change how you should think about your debt, estate planning, and what you actually owe to your family. In this video, we're going to cover three things. First, legal rule that determines what actually happens to debt after death, and why most people have it backwards. Second, which debts your family can actually be forced to pay, and which ones simply disappear. And third, the specific situations where things get complicated, and what you can do right now to protect the people you leave behind and love. This is not legal or financial advice. I'm simply breaking down how the law works so you can have a more informed conversation with your own attorney or financial planner. But what I am about to tell you is black letter law. It's settled and it matters. Here is the fundamental rule. When you die, your debts do not disappear, but they also do not automatically transfer to your family. Instead, they become the responsibility of your estate. Your estate is everything you owned at time of death. Your bank accounts, property, investments, personal belongings. Before any of that passes to your heirs, your creditors have a legal right to make a claim against it. This process is called probate, and in many states, creditors have a window, typically 3 to 6 months, to file a claim against your estate. So what this means in practice, if you die with $50,000 in credit card debt and $80,000 in assets, your creditors will be paid first. Your family receives what's left. If you die with $50,000 in debt and only $20,000 in assets, the creditors absorb the loss. Your family owes nothing more. Your debt dies with the estate. Now, there are important exceptions, and this is where most people get confused or where they can get taken advantage of. Secured debts are different. If you have a mortgage or a car loan, those debts are attached to specific assets. If your family wants to keep the house, they need to keep paying the mortgage. The lender has a lien on the property. Your death doesn't remove it. If no one continues payments, the lender can foreclose. Joint debts are different. If someone co-signed a loan with you, a spouse, a parent, an adult child, they're fully liable for the entire balance after your death. This is one of the most financially devastating surprises families face. Co-signing is not a formality. It is a full legal responsibility. Community property states are different. If you live in Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, or Wisconsin, your state may treat debts incurred during marriage as joint debts, regardless of whose name is on the account. Student loans. Federal student loans are discharged at death, completely. No claim against your estate, nothing owed by your family. Private student loans are a different story. It depends on the lender's terms and whether anyone co-signed. Now, this is the part you really want to pay attention to, because this is where a lot of families will get exploited. When someone dies, debt collectors often contact family members. They make calls, send letters, and use language that implies the family is responsible for paying. In many cases, they are not. Under the Fair Debt Collection Practices Act, collectors are legally limited in what they can say and do to people who are not actually liable for a debt. They are allowed to contact a surviving spouse, the executor of the estate, and the parents of a deceased minor child. They are not allowed to deceive non-liable family members into believing they owe money they don't. But it happens constantly because most people don't know their rights, and grief makes people very vulnerable. If a debt collector contacts you about a deceased family member's debt, the first thing you do is ask in writing, am I legally liable for this debt? They are required to tell you the truth, and in most cases, it's no. So here's what all of this means for you right now. 1. Know what you have co-signed. Any debt with your name on it as a co-signer survives your co-borrower's death, and it becomes entirely your responsibility. Review these obligations now. 2. If you're in a community property state and you're married, understand which debts your spouse is carrying. Their debts may legally become your problem. 3. If a debt collector contacts you, about a deceased family member's debt. Do not pay anything until you have confirmed in writing that you are actually liable. You almost certainly are not. 4. If you have significant assets and significant debt, talk to an estate planning attorney about how your estate will be administered. The decisions you make now determine what your family actually receives. The law is actually more protective of families than most people realize. The problem is, nobody tells you until it's too late. If this is the kind of thing you wish someone had explained to you sooner, there's a lot more where this came from. Subscribe to Black Letter Money. This is what we do here. The law and the money. Together, explained clearly. Thank you for joining, and I'll see you at the next one.